Okay, I need to tell you something, and I need you to stay with me here, because what happened this afternoon in a federal courthouse in Manhattan is not just another legal development. This is the moment. This is the point where all the procedural games, all the delay tactics, all the emergency motions and appeals to higher courts, all of it just ended. At 2:47 p.m. Eastern Time today, Judge Lewis Kaplan signed an order that no federal judge in American history has ever signed, an expedited sentencing order for a former president of the United States with a locked date 72 hours from now and explicit language stating that no further delays will be entertained under any circumstances. If you care about whether the American legal system can actually function when someone decides the rules don't apply to them, you need to understand what just happened, because this is one of those moments we'll be talking about for decades. Let me walk you through the sequence of events, because the details here matter enormously. For the past 8 months, Trump's legal team has been running a playbook that's worked for them in virtually every other case. File motions, demand hearings, appeal every ruling, claim bias, request recusal, challenge jurisdiction, seek emergency stays from higher courts. The strategy has never been to win on the merits. The strategy has been to delay long enough that political circumstances change, that public attention fades, that witnesses forget, that evidence degrades, that anything happens to make the whole problem go away. That playbook just got shredded, not because Judge Kaplan suddenly became impatient, not because he's biased or political, or any of the things Trump's team will claim in the next few hours, but because the judge concluded and documented in 58 pages of legal reasoning that the delays themselves have become a form of ongoing criminal conduct. Here's what you need to understand about how federal courts actually work. Defendants have rights. They have the right to appeal. They have the right to challenge rulings. They have the right to adequate time to prepare for sentencing. Those rights are fundamental to the system. But here's what most people don't understand. Those rights are not unlimited. They can be forfeited through misconduct. And that's exactly what Judge Kaplan's order documents in excruciating detail. Since the guilty verdict was delivered on November 18th, Trump has violated court orders 23 times, 23 documented instances, posting on social media about witnesses, attacking prosecutors by name, threatening jury members indirectly through coded language. His supporters understand perfectly, discussing case details he was explicitly ordered not to discuss. Each violation was documented. Each one was brought to the judge's attention. Each one resulted in warnings, then fines, then contempt citations, and each one continued anyway, because the calculation was simple. Pay the fines, absorb the contempt findings, keep delaying, keep attacking, keep the base energized, keep hoping something breaks your way. Judge Kaplan's order states, and I'm reading directly from page 14, that the defendant's post-conviction conduct demonstrates a clear intention to use procedural delays not as legitimate legal strategy, but as a platform to continue intimidating witnesses, influencing potential witnesses in related cases, and undermining public confidence in the judicial process itself. That language is devastating because it's not emotional, it's not political. It's a federal judge's factual finding based on documented evidence, and here's why that matters so much. Once a judge makes a factual finding that delays are being used for improper purposes, the entire calculus changes. The defendant's rights to appeal don't disappear, but they no longer justify indefinite postponement of sentencing. The judge can, and Judge Kaplan just did, set a firm sentencing date and declare that absent truly extraordinary circumstances, that date will not move. The order came down at 2:47 this afternoon. By 3:15, Trump's legal team had filed an emergency motion with the Second Circuit Court of Appeals, seeking an immediate stay. By 4:30, the Second Circuit had denied that motion in a single paragraph. No explanation, no analysis, just denied. Trump's attorneys then filed an emergency application with the Supreme Court. As of this recording, there has been no response. And here's what legal experts are telling reporters tonight. There won't be a response, because the Supreme Court has already ruled on the underlying conviction. They've already declined to hear Trump's appeals on the merits. They've already established that this case was properly tried and the verdict was sound. What Trump is asking them to do now is not review a legal question. He's asking them to second-guess a trial judge's scheduling decision. The Supreme Court doesn't do that. They don't micromanage trial calendars. They don't step in to delay sentencing hearings unless there's a genuine constitutional issue at stake. And every legal analyst reviewing this situation tonight is reaching the same conclusion. There's no constitutional issue here. There's just a defendant who doesn't want to face sentencing. So the sentencing is happening. 72 hours from now. February 8th at 10 a.m. Eastern, Judge Kaplan's courtroom. And here's where this gets genuinely unprecedented. Federal sentencing hearings normally happen weeks or even months after conviction. There are pre-sentencing reports, there are victim impact statements, there are character witnesses, there are sentencing memoranda from both sides arguing for specific outcomes. All of that machinery takes time. Judge Kaplan's order makes clear that all of that has already happened. The pre-sentencing investigation was completed in December. Both sides submitted their sentencing memoranda in January, the victim impact statements, and yes, there are victims in this case. Election officials who faced death threats, poll workers who went into hiding, have all been compiled and reviewed. Everything is ready. The only thing that's been missing is a date that wouldn't move. Now there's a date, and it's not moving. I want you to understand what's going to happen in that courtroom on Saturday morning, because this isn't like anything we've seen before. Trump will be required to appear in person. He cannot appear by video. He cannot send his attorneys to represent him. Federal rules require the defendant's physical presence at sentencing. He'll sit at the defense table. Judge Kaplan will review the evidence. The judge will hear brief statements from both sides. And then Judge Kaplan will impose sentence. The federal sentencing guidelines for the crimes Trump was convicted of are not ambiguous. Obstruction of justice, witness tampering, conspiracy to defraud the United States. The guidelines recommend between 87 and 108 months in federal custody. That's 7 to 9 years. Now, judges have discretion. They can depart downward from the guidelines if there are mitigating factors, and Trump's team will argue for exactly that. They'll point to his age, 78 years old. They'll argue he's a first-time offender, at least in the sense of never having been convicted before. They'll claim the guidelines are too harsh for someone of his stature and public service. But here's what prosecutors will argue, and here's what Judge Kaplan has already signaled in previous rulings. The guidelines exist for a reason. They're designed to ensure proportional punishment and deterrence. And in cases where the defendant has shown absolutely no remorse, where the defendant has actively obstructed justice even after conviction, where the defendant has used his platform to intimidate witnesses and undermine the judicial process itself, downward departure is not appropriate. Judge Kaplan has made comments from the bench during the trial that legal observers noted carefully. He stated at one point that this case involves not just crimes against specific victims, but crimes against the constitutional order itself. He said that accountability at the highest levels of government is essential to maintaining the rule of law. Those statements weren't casual remarks. They were previews of his thinking, and they suggest he's not inclined toward leniency. So what happens after sentencing? This is where it gets complicated in ways the American system has never had to address before. If Judge Kaplan imposes a custodial sentence, and every indication is that he will, Trump will be remanded to custody immediately. That means U.S. Marshals will take him into custody right there in the courtroom. He won't go home. He won't have time to get his affairs in order. He'll be transported directly to a federal detention facility. Now, former presidents receive Secret Service protection for life. That protection doesn't end because of a criminal conviction. So you're going to have a situation where Secret Service agents are protecting a federal prisoner. The Bureau of Prisons has apparently been preparing for this possibility for weeks. They've identified a facility that can accommodate the security requirements. They've developed protocols for how Secret Service protection works inside a federal prison. This has never been done before. There's no manual. There's no established procedure. They're writing it in real time. And here's the other element that's causing absolute chaos in Washington right now. Trump is still technically a candidate for president. He's the front-runner for the Republican nomination. He's leading in most polls. The Iowa caucuses are in 2 weeks, and if he's sentenced to federal prison on Saturday, he'll be conducting his presidential campaign from a detention facility. Think about what that means practically. No rallies, no public appearances, no campaign stops. Communication with his team will be monitored. His access to social media will be restricted. His ability to fundraise will be severely limited. His entire political operation, which has been built on his personal presence and his ability to dominate media coverage, will have to operate with him physically removed from the public sphere. Republican Party leadership is in complete crisis mode tonight. They have no idea how to handle this. Do they stand by him? Do they call for him to withdraw? Do they try to change party rules to prevent a federal prisoner from being the nominee? There are frantic conference calls happening right now. There are donors pulling funding. There are rival candidates trying to figure out whether this is their moment to strike or whether attacking Trump while he's being sentenced will backfire with the base. The Iowa Republican Party chairman released a statement an hour ago saying the party respects the judicial process and will not comment further at this time. That is not a defense. That is not support. That is panic translated into corporate speak. And internationally, this is being covered as the lead story everywhere. BBC is running continuous coverage. Al Jazeera is treating this as a constitutional crisis. Russian state media is gleefully reporting on American instability. Chinese news outlets are framing this as evidence of Western democratic decline. Our allies are watching carefully but nervously. The idea that the United States, the country that has lectured the world about rule of law and democratic accountability for decades, is about to imprison a former president, is generating reactions that range from respect for the system holding to concern about what this means for American political stability going forward. Let me tell you what we're hearing from inside Trump's inner circle tonight, because this is where you see the reality breaking through the public bluster. Multiple sources describe the scene as beyond panic. It's resignation mixed with rage. Trump himself is reportedly refusing to accept that this is actually happening. He's still insisting that the Supreme Court will intervene. He's still convinced that something will break his way at the last minute, because it always has. His attorneys are trying to prepare him for the reality that he needs to appear in court on Saturday and that he needs to be prepared for the possibility of immediate detention. Those conversations are not going well. One source described it as talking to someone who genuinely cannot process that the legal system is actually going to treat him like any other defendant. And here's what's happening with potential witnesses in other cases, because Trump faces 3 other pending criminal prosecutions. The federal case in Florida over classified documents, the Georgia RICO case over election interference, the New York case over financial fraud. Witnesses in those cases have been watching these proceedings carefully, and what they're learning is that cooperation might not just be strategically smart, it might be legally essential. Because if Trump is actually going to federal prison, if the system is actually going to hold him accountable, then the calculation changes entirely. Staying loyal to someone who's behind bars and can't protect you becomes much less appealing. We're hearing reports tonight that at least 2 witnesses in the Georgia case, who previously refused to cooperate, are now reconsidering. Their attorneys are reaching out to prosecutors to discuss potential immunity agreements. This is what prosecutors call a cooperation cascade. One conviction creates pressure that leads to more cooperation, which leads to more evidence, which leads to more convictions. Let's talk about what Saturday morning is actually going to look like, because the security preparations tell you everything about how seriously this is being taken. The federal courthouse in Manhattan is going into complete lockdown. The entire building will be closed to the public, except for credentialed media and court personnel. Every entrance will have magnetometers and manual searches. NYPD is deploying additional units to create a security perimeter 3 blocks in every direction. Federal airspace over Manhattan will be restricted. The Secret Service has requested and received tactical support from multiple agencies. Why all this security? Because law enforcement has received what they're describing as credible threats. Trump has been posting continuously since the sentencing order came down. His language has escalated from claiming unfairness to suggesting that his supporters need to take action. One post from this evening reads, "If they can do this to me, they can do it to anyone." Real Americans know what's at stake. That kind of language, vague enough to maintain deniability, but clear enough that his supporters understand the message, is exactly what law enforcement feared. And there are organized groups planning to be in New York on Saturday. Pro-Trump demonstrators are coordinating travel. Proud Boys' social media channels are discussing the sentencing. Online forums are filled with discussions about what happens if Trump is taken into custody. Law enforcement is taking all of this extremely seriously. The memory of January 6th is fresh. The knowledge that Trump's rhetoric can translate into violence is established fact. So they're preparing for the possibility that this sentencing hearing could become a flashpoint. What happens if Trump calls for his supporters to prevent his detention? What happens if crowds try to block the courthouse? What happens if violence breaks out? Those scenarios are being gamed out right now in law enforcement command centers. Here's what Judge Kaplan wrote on page 47 of his order. I want to read this to you directly because it captures something essential. The court recognizes that sentencing a former president creates unprecedented challenges. However, the alternative, allowing a defendant to escape accountability through delay and intimidation regardless of their former office, would create a precedent far more dangerous to the republic than any short-term disruption this sentencing may cause. The rule of law means nothing if it does not apply equally to all persons regardless of their power, wealth, or previous position. That paragraph is going to be quoted in law schools for the next 100 years, because it articulates the fundamental principle at stake here. Either we have a legal system where the same rules apply to everyone, or we have a system where power creates immunity. There's no middle ground. Judge Kaplan has chosen to enforce the first principle even though it's harder, even though it's unprecedented, even though it creates chaos. Now let me tell you what Trump's legal team is planning for Saturday. Because they're not going down without trying everything. They're preparing a last-minute motion asking Judge Kaplan to reconsider. That motion will be filed Friday evening. It will argue that new evidence has emerged, though what that evidence is remains unclear. They're hoping that a Friday evening filing might delay things, might force the judge to hold a hearing, might create some procedural confusion that buys time. Legal experts say this has virtually no chance of success. Judge Kaplan has already ruled on every possible legal argument. There's no new evidence that could change the fundamental facts, and the judge has made clear that he will not be moved by procedural gamesmanship. But Trump's team has to try something, because the alternative is walking into that courtroom on Saturday with nothing. The other element that's being discussed is a potential presidential pardon. Now, Trump can't pardon himself anymore because he's no longer president. But there are some Republicans floating the idea that if a Republican wins the White House in 2024, they could pardon Trump immediately upon taking office. This is being discussed openly on conservative media tonight. The problem with this theory is timing. If Trump is sentenced on Saturday to, say, 8 years in federal prison, he'll be 86 years old when that sentence expires. Waiting until January 2025 for a potential pardon, assuming a Republican wins, means he serves at least 11 months in federal custody. For a 78-year-old man, 11 months in prison is not nothing. And there's no guarantee a Republican wins. And there's no guarantee that a Republican president would actually issue that pardon, given the political toxicity it would create. I want to step back for a moment and talk about what this means for the office of the presidency itself. Because the implications here extend far beyond Trump. For the entire history of the American Republic, presidents have operated with an implicit understanding that they were somewhat above the law. Not officially, not in legal theory, but in practice. Richard Nixon was pardoned. Other presidents who committed potential crimes were never prosecuted. The assumption was that prosecuting a president or former president would be too destabilizing, too divisive, too dangerous for the country. What's happening now is the destruction of that assumption. The legal system is saying no. If you commit crimes, you face prosecution and punishment, period. Your former office doesn't protect you. Your political support doesn't protect you. Nothing protects you except the facts and the law. That's a fundamental shift. Future presidents will now govern, knowing that when they leave office, they're potentially subject to criminal prosecution for actions taken while president. Some people think that's good, that it will make presidents more careful, more restrained, more respectful of legal limits. Other people worry that it will make presidents paralyzed, afraid to take bold action, constantly worried about future prosecution. Both arguments have merit. But what's inarguable is that the presidency just changed. The immunity that presidents have enjoyed, not legal immunity, but practical immunity, is over. And we're watching that change happen in real time. Let me tell you what prosecutors said in their sentencing memorandum. They argued that the defendant's crimes were not impulsive mistakes, but calculated attacks on the constitutional order. They argued that he used the power of his office to advance personal interests while undermining democratic processes. They argued that his continued refusal to accept responsibility demonstrates ongoing danger to the system. And they specifically argued that leniency in this case would send a message that powerful defendants face different justice than ordinary citizens. That argument is going to resonate with Judge Kaplan. Everything in his judicial record suggests he believes deeply in equal application of law. He's not someone who's impressed by celebrity or former office. He's someone who reads the facts, applies the law, and imposes sentence accordingly. Saturday morning, February 8th, 10 a.m. Eastern Time. A former president of the United States will stand before a federal judge for sentencing. The judge will impose a custodial sentence likely in the range of 7 to 9 years. U.S. Marshals will take Trump into custody immediately. He'll be transported to a federal detention facility, and American politics will enter territory we've never been in before. A major presidential candidate conducting a campaign from federal prison. A former president serving time for crimes committed while in office. A legal system proving that accountability extends to the highest levels of power. This is happening. There are no more exits. There are no more delays. The procedural games have ended. In 72 hours, we'll know whether the American system can actually follow through on its stated principles. Whether the rule of law means what we've always said it means. Whether power creates immunity, or whether justice is truly blind. I'll be covering every moment of this sentencing hearing. You need to be here for it, because this is history. This is the moment future generations will study when they ask whether American democracy could hold its leaders accountable. Subscribe right now. Turn on notifications, because what happens Saturday will determine the answer to that question for decades to come. This is not hyperbole. This is not exaggeration. This is a constitutional reckoning 249 years in the making, and it's happening in 72 hours.